If your entire public role is built on being treated as a responsible actor in legal escalation who gets quoted by the BBC and the like, then a judgment like this is not just a criticism, it's a structural blow. Judges receiving your applications are being instructed to read this judgment. Defense lawyers will cite it. Courts will be alive to abuse arguments sooner. The institution has been warned in advance. And there's another consequence that follows without anyone needing to speculate. When media outlets treat certain organisations as default legal authorities and quote them routinely when a case touches politically sensitive themes, they do not just report a view, they lend legitimacy by selection. In the example that we've discussed here, the broadcaster, the BBC, speaks at length about police threshold and evidential tests, and then gives the campaign against anti-Semitism a platform to say the state cannot be trusted and that it falls to them to explore legal avenues. On the same day a judge has said their legal avenue in the Hunter case was abusive, vexatious, and cancellation motivated, that routine quotation becomes harder to justify as neutral practice. It becomes an editorial choice with consequences because the court has produced a document that directly bears on whether the organisation is an honest narrator of its own legal campaigns. So what happens next is not about whether the campaign against anti-Semitism continues to exist. I'm sure it will. The question is whether it can continue to operate as though it has institutional trust when a judge has effectively stripped that away. The organisation is now in a position where it cannot pretend this judgment is irrelevant. It cannot hide it from future courts. It has to attach it. And that's the opposite of a clean slate. And that's why the implosion is permanent.